section will focus on a 2025 update with new developments in harassment and discrimination. 2 laws specifically, the ADA and the PWFA, have been updated, and several state laws have been enacted that affect employers. This section will focus on pregnancy as a disability. While the Americans with Disabilities Act does not specifically address pregnancy, many of the conditions that are pregnancy-related could be protected by the ADA, so you should be aware of some new developments in the law. The Pregnant Workers Fairness Act, or PWFA, is a landmark piece of legislation that aims to protect the rights of pregnant workers in the United States. Signed into law in December 2022, as part of the Consolidated Appropriations Act of 2023, the PWFA marks a significant milestone in the ongoing fight for workplace equality and fairness. This comprehensive act addresses the unique challenges faced by pregnant employees and ensures that they receive reasonable accommodation to continue working safely throughout their pregnancy, unless the accommodation would cause the employer an undue hardship. Recognize that the Americans with Disabilities Act covers a variety of pregnancy-related conditions when they significantly limit a major life activity. Some of these conditions include gestational diabetes, placental abruption, lumbar lordosis or severe back pain, deep vein thrombosis, embolism or stroke, carpal tunnel syndrome, mood disorders related to pregnancy, migraines, severe morning sickness, shortness of breath and fatigue, reflux, hemorrhoids, hypertension, urinary tract infections, and varicose veins. There may be other conditions that also may be protected by the ADA. These conditions could be considered disabilities under the ADA, requiring employers to provide reasonable accommodations. So work with your HR department to ensure that your employees' rights are being protected. Now let's focus on state updates for the state of California for 2025. California employers face significant regulatory updates aimed at strengthening workplace protections, increasing transparency, and ensuring equitable employment practices. Employers need to be aware of several upcoming changes. Here are some notable changes to protect against harassment and discrimination. First, the intersectionality in discrimination laws, SB 1137, which expands California's Fair Employment and Housing Act. The law prohibits discrimination based on multiple intersecting protected categories. For example, it's illegal for an employer to reject job applicants because they have a specific combination of race and gender. Another new law is hairstyle discrimination, AB 1815, which expands the definition of race under the existing Crown Act and includes traits associated with race beyond hair texture and protective hairstyles. This law aims to prevent discrimination based on hairstyles that are historically associated with race. Also, discrimination based on driver's licenses, SB 1100. It is now unlawful for an employer to include a statement in employment materials that an applicant must have a driver's license unless the job is going to reasonably expect the duties of the position to require driving, and the employer reasonably believes that satisfying that job function using an alternative form of transportation, such as walking, biking, carpooling, or using a taxi or ride-sharing service, would not be comparable in travel time or cost to the employer. Also, whistleblower protection posting, AB 2299. The California Labor Commission will develop a model list of employee rights and responsibilities under the whistleblower laws, and employers will be required to display the list in the workplace, along with a telephone number for a state whistleblower hotline. Here are more developments in California. AB 1340, Local Enforcement of Anti-Discrimination Laws. It allows local governments to enforce their own anti-discrimination laws if they are at least protective as the state's FEHA. This provides additional layers of protection for employees at the local level. And AB 3281, discrimination regarding immigration status and age. This law voids any waiver that removes protections or rights for applicants or employees based on their immigration status, and it allows the Department of Civil Rights to bring civil actions for violations of the Federal Age Discrimination in Employment Act. SB 428 regarding harassment makes 4 substantial changes to California Code of Civil Procedure, Section 527.8, to expand an employer's ability to seek a restraining order on behalf of one or more employees who have been harassed.